So, good afternoon and welcome again, everyone, to session 2 of our Retirement and Estate Planning April webinars. Whether you're joining us for the first time or returning after this morning's session, we're really thrilled to have you. If you're here, you're likely looking for smarter, more strategic ways to make the most of your retirement and estate planning, and you're definitely in the right place. Our presenter today is someone many of you have met in our first session and in person as well. And he's someone that I've had the privilege of working closely with for years. Jim Lange is not only a CPA and an estate attorney, but he's also a nationally recognized authority on Roth IRA conversions, tax-efficient retirement distributions, and forward-thinking estate planning strategies. Jim's work has been featured in the Wall Street Journal 36 times, along with appearances in Forbes, Kiplinger's Newsweek, Bottom Line, the New York Times, the Washington Post, and many others. He's also authored 10 best-selling books with endorsements from financial legends like Charles Schwab, Ed Slott, Burton Malkiel, Jane Bryant Quinn, and the late Larry King. What sets Jim apart isn't just his credentials or his national recognition. It's his ability to take dense and often overwhelming tax law, translate it into clear, actionable strategies, and relate them to his clients and viewers like you. From writing the first peer-reviewed article on Roth IRAs in 1998 to forecasting the end of the stretch IRA years before it became law, Jim has consistently been ahead of the curve, and he's developed practical solutions to help clients minimize taxes and maximize impacts. Through his interrelated companies, including our CPA firm that prepares over 750 tax returns a year, and our registered investment advisory firm that helps clients plan for more than $1 billion in assets, Jim and our team have spent decades helping families build comprehensive financial master plans tailored to their unique situations. This afternoon's estate planning focused session builds on the foundation we started this morning, but it's packed with fresh insights and valuable takeaways. This webinar is going to be dense and packed with actionable information, whether or not you choose to work with us. You'll walk away with insights that you can put to use right away. So with that, let's dive in. Please join me in welcoming Jim Lange.
So I was cycling down the path in Johnstown, Pennsylvania, and the trail took us through a darkened tunnel, and I didn't see a large pothole in front of me, and I went down hard. I tried to get up, but I could not. And I was eventually rushed to the local hospital, and the x-ray determined I had broken my hip. The good news was there happened to be a surgeon on call. He said I needed surgery and that he could literally do it that night. And I was in a lot of pain, obviously. And I thought, well, boy, that would be good to get this done. But do I really want a general surgeon who happened to be on call in Johnstown, Pennsylvania, or does it make more sense for a surgery that could have such important implications to go to Pittsburgh and have a specialist do the surgery? So I asked the doctor, I said, well, if I waited until tomorrow to get this surgery, would it have any long-term damage by not getting the surgery quickly? They said, no, you'll have a very uncomfortable night, but there shouldn't be any long-term damage to just wait. I thought, oh, okay, great. And I was able to secure an appointment with a specialist who specialized in hip trauma surgery in Pittsburgh the next morning. So I was transported by ambulance to Pittsburgh. I had the surgery in the morning. And after the surgery, I put together a team. I had a nutritionist who interestingly told me information much different than I would have expected, an acupuncturist, a physical therapist, and we all worked, and an exercise physiologist. We all worked together in effect so I could have a complete and full recovery. And when I went back to the surgeon for my first checkup, he said, and I was in my 50s at the time, he said it was the fastest recovery and the best recovery he had ever seen. And why do I start a financial and estate planning workshop with this story? And the reason is I was in a position that I could have used a generalist, but instead I chose to put together a team of specialists to work on my specialty situation. Most of the people that I work with have a significant or often the largest asset in their portfolio is their retirement plan, whether it is an IRA, a 401k, a 403b, a SEP, a KEO, etc. But many still go to a generalist advisor when there are specialty issues involved. And we talked the first session mainly about the current environment and Roth IRAs and Roth IRA conversions. And I talked about even the differences between some of the advice I was giving as little ago as a year ago, or even less than a year ago, and now. And now what I'd like to do is to kind of shift the emphasis to what I call the dying part or the estate planning part. And I will, the theme of it is going to be what I consider the best estate plan for most married and retirement plan owners. And I should also mention, and I just barely mentioned it this morning, but in 1998, I did a peer review article for the American Institute of Certified Public Accountants. And at the time, both as a financial advisor and an estate planner with an existing law firm, that we ended up doing more than 3,000 wills and estate plans similar to many of the concepts that I'm going to be talking about today. And I was so excited about these concepts, even though it wasn't really on point with Roth IRA conversions. I put let's say the highlights of the estate planning that I'm going to be recommending today into that peer-reviewed article. And I totally expected the peer reviewers to say, hey, this is an article on Roth IRA conversions. You're introducing this new topic of estate planning, and not only just estate planning, but your specific view of estate planning. This has no room for our article. And I was planned to accept that. Instead, the peer reviewers loved it. And they said, hey, could you expand this section on estate planning? And which I did. And it was sent out. And that was, let's call it the world's early introduction to, and it goes by different names. If you go to the snooty peer-reviewed literature or even the Wall Street Journal, it will be called the Cascading Beneficiary Plan. I prefer naturally to call it Lange's Cascading Beneficiary Plan, but I'd like to delve into some of the details of that today, talk about the differences between that and traditional planning, and perhaps give you some ideas of how you might consider changing your own wills, trusts, and estate plan, and why it's even more important to get this right today than perhaps at any time in history, if you will. We're also going to talk about that plan. We're going to talk about let's say, the downfall of doing nothing, which is what most people do when they end up dying with inappropriate wills, trust, and estate planning. And of course, the details of what I consider, not for everybody, but for a lot of people, particularly people with traditional marriages, of the best likely estate planning solution known as Lange's Cascading Beneficiary. Also, because I can't help myself, I'm going to throw in a couple of advanced concepts that really are not so much, they're related, but they're different than Lange's Cascading Beneficiary Plan, something that we've been using in practice for years, that when you hear it, you're going to go, oh, yeah, that's obvious. Why didn't my guy tell me that? Which I call Who Gets What, which we think is a very cool plan, which we have implemented that have saved families tens or even hundreds of thousands of dollars. We're also going to be talking about controlling from the grave, and we're going to be talking about trusts. And I won't be able to spend as much time as I like on them, but I'll be talking about some of the important facets of trust planning, when you should consider having one, when you should consider it not being necessary, and when you can use a trust as a contingent beneficiary. So we're going to, within the next hour or so, talk about the solution. But I think what is really critical is to get a good idea of the background and why this solution is the best. So we're going to be talking about the concepts, why it is so well revered. It has been featured in the Wall Street Journal multiple times and in many sources. I include it in most everything that I write. And again, we've had the highest reviews, the highest testimonials from the top experts in the country, including many estate planning lawyers that have endorsed this plan. Again, we'll also talk about trusts. And finally, what I call the solution, the answer, the holy grail of estate planning, that you probably, unless you have been working with me or known of my information for years, you probably do not have this in your current documents. And you might very well think, hey, maybe this is something that I should have. So let's talk a little bit about not just the new environment with regards to investments in the market, which I think I covered maybe even more than some people wanted in the first session, but I do want to talk a little bit about the Secure Act. I mentioned it just briefly. But back in the old days, I'm talking about pre-2020, if you died with an IRA, a 401k, a Roth IRA, a Roth 401k, all of these types of retirement plans, and you left it to a non-spousal heir, who would most likely be a child, a grandchild. By the way, it could be anybody who isn't your spouse, because the rules for spouses did not apply to this new law. The old law said that beneficiary could stretch or defer distributions on this inherited IRA, 401k, 403b, SEP-KEO, etc., over their lifetime. So I was always been a big fan of pay taxes later, even after you died. So let's say that you died with $1 million IRA, and let's assume for discussion's sake your spouse had passed, and now the money is going to a child. And let's just say for discussion's sake that the child was 50 years old at your death. And that child, according to the tables, had roughly, let's say, a 30-year or a 35-year life expectancy. Well, the way you would calculate the then what's called the minimum required distribution of the inherited IRA is you would take a factor, and that factor was a fraction of 1 divided by the life expectancy of the child. So let's say it was 33%, just to pick a nice, easy number, 33-year life expectancy. So you take 1 over 33, which is roughly 3%, and that would be the minimum required distribution over times, or you multiply that times the balance as of December 31 of the prior year. So let's say 3% times $1 million. So the minimum required distribution of the inherited IRA was $30,000, or if you're using 33%, $33,000. Then it was 1 over 32. Then the following year, 1 over 31, then 1 over 30. So you would have an ever increasing minimum required distribution because the factor that determined your minimum required distribution was going down and down and down. But if you left that money to a grandchild, then instead of having a 30-year life expectancy, might have a 60-year life expectancy, you would get an even smaller minimum required distribution. And we played a lot of games getting IRA and retirement plan money to children and grandchildren so that they would get this enormous benefit of the inherited stretch IRA. And by the way, that is still the law if your beneficiary meets a number of conditions, and one of those conditions is if they have a disability, and I won't get into the definition of that, but let's assume that they do qualify as having a disability, like my daughter, and she is considered an eligible designated beneficiary. And that means that she qualifies under the old law. So she could take an inherited IRA, inherited 401k, et cetera, and stretch that inherited IRA, 401k, Roth IRA, et cetera, over her lifetime, which means it would be worth a lot more to her than it would be to a beneficiary that doesn't qualify as an eligible designated beneficiary, who was caught, like most of your kids will get caught, with this miserable Secure Act. And the Secure Act says that the beneficiary must withdraw that money within 10 years of the IRA or 401k or Roth IRA owner's death. So we have this potential massive income tax acceleration, which instead of 30 years, 40 years, 60 years of tax deferral or continued tax-free growth with the inherited Roth, we have this massive income tax acceleration on a traditional IRA or a big, let's say, tax-free distribution within 10 years of your death. So that is going to make it much harder to provide for your child or children or grandchildren in a meaningful way. So it's even more important today to maximize your planning so that your family can get the most out of what you've got, and in a way that, let's say, the status quo isn't nearly as favorable as it was if for deaths before 2020. Now, there's some very important exceptions to this income tax acceleration of the Secure Act. The most important being your surviving spouse. That's mission critical. Your spouse is not impacted by the Secure Act. Excuse me, they could do either a rollover, or we prefer to call it a trustee-to-trustee transfer to the next for themselves. So they, in effect, take the place of the IRA owner, and that's usually the best thing to do. Another exception that we're not going to cover today are qualifying charitable trusts, which, by the way, are much more interesting than is well documented in the literature, and they are much more favorable. Even for people who are not as charitable as you might think, they are still very good for both, well, of course, very good for charity, but not as bad for families as you might think. And it kind of emulates, in a way, some of the old law, but we're not going to get into that because we only have so much time. If your beneficiary is not more than 10 years younger than you, typically that would be a spouse, or, I'm sorry, a unmarried partner, or it might be a sibling. Or, as in my family, since my daughter has a disability, she will not be subject to the Secure Act. She qualifies as the exception, that she'll be able to defer or put off the distributions for an inherited IRA that me or my wife could leave, or, ready for this one, what her grandfather might leave her in his IRA. And I take a special emphasis on that because this is an original idea. It will mainly apply to people who have a child with a disability whose parent is still alive. And we did that ourselves. Well, we didn't do it. Grandpa's still alive. That's Walter, the family vacation guy, who is 100 years old. But at his death, the portion of his IRA that would normally be going to his daughter, my wife, will end up going into an appropriate trust for the benefit of our daughter, and she'll be able to stretch that over her entire life, creating hundreds of thousands of dollars of additional purchasing power for her over her life, using a strategy that I hadn't heard of anybody using this strategy. So it's just one of those things. And I do a lot of stuff, by the way, that when you hear it, you say, well, that's obvious. But then, well, why is it new? So I am going to be talking about a bunch of stuff that is either, well, a lot of it goes back to 1995, so it certainly isn't new now, but it is still not common, and it's still by far a minority position in the estate planning world when I think it should be, let's call it the standard quo, and only deviate from it if you have good reasons. But anyway, the Secure Act is a very important type of law that we have to pay attention to. So I want to talk about two types of taxes that is relevant for estate planning. The first type of tax, which we are mostly familiar with, is the income tax. Every year we file a Form 1040. The deadline of that is just passed, and we have to pay taxes on our income. And when we die, if we die with an IRA or a retirement plan for which we have not yet paid taxes, somebody will have to pay income taxes on that money. And that is very important in the big picture of the optimal way to plan for your estate. The second type of tax is the estate tax, which is really more accurately described as a transfer tax. And what they used to say in law school was if you had a tree, and let's say it was a fruit-bearing tree, and the fruit that came off of the tree, let's say it was an orange tree, and you harvested the oranges, and you sold the oranges, and you received compensation for your oranges. In effect, the compensation that you received for selling the oranges would be subject to the income tax. And if you were an orange grower, you would have to pay income tax on what you sold the oranges for, less your expenses. The estate tax, that's actually who owns the tree. I own the tree, I transfer it to my daughter, subject to exclusions, I would have to pay a transfer tax. So we have these two types of taxes that we have considered. And in the old days, and even still today, many, in my opinion, attorneys who aren't getting it right, which is unfortunately, I don't want to say the majority, but I'll say a lot of them, they are more interested in the documents that they are preparing and the plans that they are recommending are more geared towards saving transfer taxes instead of income taxes. Well, in 2025, we each have a 13.99, let's just round off and call it a $14 million exclusion, meaning we don't have to pay, I'm not going to get into the real technicals, but here's the gist of it. For single people, the first $14 million that we own or transfer at our death to a non-spousal heir is not subject to transfer tax, federal transfer tax. Or for a married couple, using something called portability that I'm not going to get into, we have a $28 million exclusion or exemption from transfer taxes. So most people, if they're married, they have, most of my clients, I don't have, $50 million clients. I'm probably, most of my clients are in the, probably the 1 to 10, some 20, occasional, I have occasional clients, but I don't serve the $50 million people. I'm more in the $2 to $10 million range. So federal transfer tax is not that big an important issue for most of my clients. All right. Now you could say, oh, Jim, but the Tax Cut and Jobs Act of 2017, that was supposed to sunset in 2026, in which case the exclusion, instead of being $14 million, will be roughly maybe 7.5 million per taxpayer, or $15 million for a house for a husband and wife. And that is scheduled to be effective in 2026. Now, we think that President Trump and the Republican Congress are probably going to extend the Tax Cut and Jobs Act of 2017. So I'm even less worried. So I'm not so worried about that, that sunset provision of the 2017 Act, but what I am and I don't think it's going to happen. And even then, a married couple still has $15 million of exclusion. So I kind of want you to not concentrate so much on transfer tax, which most of the people on this webinar are not going to be subject to, but I'd like you to concentrate on income tax, because that's what practically everybody who's on this webinar's estate will be subject to, which is the income on their inherited IRAs, 401ks, etc. This, by the way, brings up an important point. And this is this one concept is potentially mission critical. So today, we had a guy who was 78 years old. He didn't say how much money he had, but he said that he was making gifts of $19,000 per year to each of his kids. And I took that to mean a couple of things. One, he was probably not married at this point, because otherwise he could have made a gift of $38,000 per donee for a husband and a wife, and he just said he was giving $19,000. And by the gist of his question, I got the impression he was much more interested in the well-being of his kids, because he had more than enough money to take care of himself. But he felt that he was limited to making a $19,000 gift. All right. And the truth is, he really is likely not. So what is that $19,000? What that means is that is the amount that you can give to a child, or it doesn't have to be a child, but most likely a child, maybe a grandchild, without eating into your exclusion. Well, if you're not going to be anywhere near your exclusion at your death, who cares if you eat into it? So I'm going to take an extreme example. Let's say that you wanted to give your kid $1,019,000 as a gift. All right. Now, obviously, that's not what you're likely to want to do. On the other hand, I have recommended and overseen the gifts of multi-million-dollar gifts. But anyway, let's just say, for discussion's sake, that you wanted to make $1,019,000 gift to your kid. You said, hey, wait, Jim, I thought I was only allowed to make a $19,000 gift. And that's right if you are trying to preserve your whole exclusion. But let's say you're married, now your federal estate tax exclusion is 28 million. And even if the Tax Cut and Jobs Act of 2017 sunset provision takes effect, and it'll go down to 15 million, and let's say you're nowhere near that, and you eat into your exclusion, so instead of it being, say, 28 million or 15 million, it'll be 27 million or 14 million. Well, who cares? If your exclusion is 28 million and you eat into it by $1 million, yes, you have to file a gift tax return, but who cares? So one of the things that I want to talk about, actually, I just want to mention now, is don't feel compelled to be limited to that $19,000 or $38,000 per year exclusion. And there's some big benefits to gifts. It does get money out of your estate, which might be subject to a state inheritance tax. But probably more importantly, it allows children to have access to money when they need it, instead of when, frankly, their large inheritance isn't as meaningful. I'll just give you an example. Let's say somebody gave you $100,000 tomorrow. Happy birthday, here's $100,000. For most of my clients, of course, it's wonderful to get a gift of $100,000, but for most of my clients, it would not be life-changing. They would probably not change where they live. They would probably not go out and buy a new car. They would probably not say, oh, let's take this $100,000 and blow it and go on a round the world vacation. They wouldn't do any of these things. Some of them wouldn't even go out to dinner. They would just say, oh, that's nice. We'll put it in our investments and life will go on. So it might not be all that meaningful later in life after you're financially secure, or at least relatively financially secure, to get a really large gift, or in this case, we're talking about a bequest. But what if somebody gave you $50,000 30 years ago? Oh, that's a different story, because 30 years ago, you were in a different financial position. That might have paid for your kids' college education or more. That might have helped you with mortgage payments. That might have helped you do some of the things that you wanted to do, maybe even including a vacation or something like that. And by the way, with inflation, the $50,000 30 years ago is roughly like $100,000 today. So my point is, your kids might be in that same situation where they could benefit a lot more when they are younger and they're starting their families and they have college education and they have their housing and they have their life insurance and they have all their issues, and they don't have the benefit that many of my existing clients have, which is not guaranteed full employment for life, but let's just say a much more likely steady stream of continued work that will allow them to build up their retirement plan over time. And even Albert Einstein talks about the miracle of compounding interest, with steady contributions of money into a 401k or a retirement plan, both your share and the employer's share, who over time is one of the reasons why so many of my clients have done so well. I don't tend to get the silver spoon clients. I don't even really look for those folks, or even look for the business owner who went out and started with nothing and he built a $10 or $20 million business. Most of my clients, they started out with maybe not a heck of a lot, and they didn't walk into fantastic jobs the first year that they worked. But they did get a job. Maybe I have a lot of professors, I have a lot of engineers, I have a lot of mid-level managers, people in corporate America, people in small business, but not necessarily business owners. And these folks typically were conservative, didn't make a ton of money, but they worked for a company that had a retirement plan. In the old days, a pension plan, more recently a 401k, or both. They continued every month to put money into that retirement plan, and their employer, there was usually some kind of match, and that money built up over time. And that's where the position of a lot of our clients are, is they have significant IRAs and retirement plans, but it doesn't mean that you can, even if you have to take, and in some advanced situations, we're actually recommending they withdraw some of their IRA money, pay the tax on it, have after-tax money left, and gift that. Because a lot of times it just makes a lot of sense for people to gift. I usually, not always, I usually try to get people to spend more than they are. Most of my clients are relatively thrifty and are not spenders, but sometimes I might be more successful in trying to talk about the benefits of gifting. So one of the issues, and I'll just do a quick story of two families, both of them multi-million-dollar families. Both of them led, I'm going to say, nice lives, but none of them were, huge spenders that went out and bought boats and, multi-million-dollar homes and lavish vacations. They were living, let's call it middle or upper middle class lifestyles. And they each had a kid that went into the nonprofit sector, not making a lot of money. And one was very, very reserved in making gifts to their child. And I'm not saying they never gave him anything, but really nothing very significant. All right. And they will continue doing that until their death. And that child will inherit, let's just even say between $5 and $10 million when they're maybe as late as their mid 60s. Not going to mean all that. Yes, it'll be good then. But what if instead they would have done what another family of mine did, which has been very generous with their child who worked for the nonprofit. The child was doing good, useful work, so it wasn't a matter that they were slackers or didn't have any motivation. They did, in both cases, they did good work for this nonprofit, both of which the families believed in. But the one family helped their son in a major way. So their son could afford to get married, have a house in a nice neighborhood, be able to afford to have kids, be able to afford to pay for their kids' college education. And the difference was just astounding. Another client, they decided to retire in the same city as one of their children, and they bought their child a condo right next to theirs, which the child could never have afforded on their. Well, boy, isn't that smart? And have that child be in a really nice place with a built-in babysitter, next door. I think sometimes it makes sense to be generous while your kids are young. Okay, let's go back to estate planning and let's talk about what has always been a problem, but I would say today this problem is exacerbated. And the problem that I'm talking about is uncertainty. All right, we've always had uncertainty, but now in the current economic condition, which I talked more about at the beginning, I would say uncertainty is greater than it has been since I can remember. We were having wild fluctuations at the time of this webinar, basically going down in terms of our portfolios with what is going on with tariffs and other economic factors. Will it go back up? It certainly has historically over time. When will it go back up? Will it go back up soon? Will it go back within your lifetime? We just don't know. And maybe it'll go back and go well higher. And maybe some of these things are ultimately going to work out. Or maybe, I think what a lot of us are hoping is that the tariffs will be reduced or eliminated. And typically what has happened historically after tariffs are reduced or eliminated is the market goes up again. In fact, we actually saw that when the tariffs were brought in, and there was a moratorium, and boom, there was a big lift, and then there was some talk about doing some things that the market doesn't like, and then it came back. But anyway, my point is that we are living in an age of extreme uncertainty when it comes to how much money we will have at our deaths. The other problem is how much money will we have then if we are married. Usually the big transfer of wealth happens at the second death. How much money will our spouse have? The other issue is, well, there's many issues, but the other area of uncertainty is what will the law be when you die? There was a radical change in the treatment of inherited IRAs if you died in 2019 versus if you died in 2020. And literally on $1 million IRA, it might be the difference between dying on December 31, 2019 and January 1, 2020. That could have made $1 million difference for your kid. And that is, huge, which will we go back to the old law, or will this current law stay? What's going on with the estate tax exclusion, which is going to potentially be cut in half, but then again, it might not matter, and maybe it won't get cut in half. And then if so, when? We have the step up in basis rules, which I predict are not going to be around indefinitely. I think they will likely be around for the Trump administration, but again, who knows? With looming deficits, frankly, it's easier to tax dead people than alive people. So who knows what the law is going to be? Who's going to die first? A lot of times we do planning, and a lot of times we assume that the guy's going to die first, both because us men live actually less time. Sometimes we are older than our spouse. I'm not. My spouse is older than I am, which he doesn't like being reminded of. And if I was more of a gentleman, I would never bring it up, but I still do anyway. But anyway, who will die first? What are the needs of the survivors? We don't know. Maybe one kid who's doing great now is going to be in trouble. Another kid who's in trouble now, maybe they'll be doing great. And that makes a change. What will the tax rates be? Again, huge variations on what could happen. Where will you die? I have a national practice, but earlier and for many years, I had mainly a local practice, and it was in Pittsburgh, Pennsylvania, and most of my clients lived and died in Pennsylvania. Now, as time goes on and my clients are getting older, a lot of them are moving to the same state where one of their adult children is. And by the way, for some of you who have a daughter in a different state, there might be a little pressure to move to that state when that daughter has a child. Interestingly enough, this is anecdotal, but there hasn't been as much movement as when a son moves. And you might get caught and move to a state where your kid is, and then your kid has to move because of work, and then you're stuck in a state that you don't want to be in. That has happened to both some friends of mine and to some of my clients. But I guess for my point here is, even though you might, and maybe you have a pretty good idea, but you might not know where you're going to die, and that could have a big impact on your state. What state will your kids or the survivors live in? That will have an impact on things like Roth IRA conversions and gifting and your estate plan. And I'll tell you, and I'm a big believer in running the numbers and doing projections, and we've done thousands of them. But they're all wrong, because something that we didn't think was going to happen happened, or the assumptions that we use, and we like to use a wide range, but let's say any one assumption that we use, something else happens. So yes, we don't want to do guesswork and not run the numbers, but we have to recognize that all the projections that we do are not going to actually be what ends up happening. So, I know this is a long introduction to the answer, but this is mission critical. My point here is there's huge uncertainty. So a couple questions. I am old enough that I define a traditional family, meaning original husband, original wife, and the same kids. I call it a Leave It to Beaver family. For you younger folks, you will not likely be familiar with that. Many of you are familiar with the old TV show Leave It to Beaver. But if you are, and I'm a Leave It to Beaver family, meaning original husband, original wife, the same child. That is, not a child from a previous marriage, not a love child from the 60s, but a child that was and adopted is the same thing, but original child that both you and your spouse had, and if that child had any children, that you and your spouse are the grandchild. But why don't we first start with getting an idea? But if I was when I used to do these workshops in person, I would ask people to raise their hand. But if you could put in the chat with a yes or no, are you married? All right. And actually, maybe you might not even want to put that in because of privacy reasons. But I'll assume if I was in the room personally, I would say most of the people that I talk to are married. Not all, but most. Next question that you may or may not want to respond to, do you have at least one child? Next question, and by the way, I'm not keeping this information. I just thought of it 1 second ago that this could be, in today's privacy age, not appropriate. But anyway, are your children from your current marriage? And you might want to at least think to yourself, yes, I'm married. Yes, I have a child. Yes, that child is from my marriage. And again, I call this the Leave It to Beaver families. So if that is the case, and let's forget about taxes for a minute. Is it your basic idea that you would say, if something happens to me, I want the money to go to my spouse. If something happens to my spouse before I die or after my spouse dies, I want the money to go to my kids, presumably equally, not necessarily, but let's assume for discussion's sake and to simplify, to my kids. And then if one of my children die before I or my spouse die, and that child has any children, that is the children of a predeceased child, your grandchildren of the predeceased child, that the grandchildren should get the share of the predeceased child. All right? Is that kind of the general idea? So common goals, protect both of us while we are alive. Spouse dies, my most important thing is taking care of the surviving spouse. Obviously, you want to take care of both of you while you're both alive, protect the surviving spouse at death. Only then does cutting taxes and leaving the most to your children really play a huge role for traditional families. Providing for your grandchild usually is the next goal. So, and usually if the grandchild's young, we usually want to do that in a trust. So, protecting your spouse, that's under the old rules and the new rules, very favorable tax rules about tax-free rollovers. We prefer to call them spousal trustee to trustee transfers from your IRA or retirement plan to your spouse. No estate or inheritance taxes, assuming your spouse is a U.S. citizen. We have an unlimited marital deduction, which applies to U.S. citizens and some non-U.S. citizens, but it's the citizenship of the spouse, not the person who dies that is controlled. No estate tax, no inheritance tax. The spouse gets the old favorable treatment of the stretch IRA, being able to pay taxes later. So lots of advantages to the spouse. And for a Roth, no minimum required distribution for Roth IRA, Roth 401k, Roth 403b. Children, there are some benefits of having some money going to the kids at the first death. The children might be in a lower income tax bracket than the surviving spouse. Remember, after you die, the surviving spouse, unless they remarry, they're going to have to file single, unless they're head of household, but that is not likely, which is going to push them into a higher tax bracket. A child, an adult child, might be in a lower tax bracket. The child might need some money earlier rather than later. And there are some circumstances where it might make sense to skip the child and have money go to the grandchild. Maybe the child doesn't need the money. Maybe there's creditors. Maybe there's the no good son-in-law. And by the way, or it might be a situation like my own, where the grandchild has a disability and the grandchild can stretch the inherited IRA or Roth IRA over their lifetime, where a spouse or another child could not. And by the way, we also have to be careful of the ever more popular, I don't want my no good son-in-law to inherit one red cent of my money trust. So let's say that that's the situation. There's advantages to spouse, kids, grandkids. What is the best solution to this problem when uncertainty is a huge factor and now more so than ever? Ready? Drum roll. Here it is, the solution. Don't decide now. Don't decide. It's too tough. But what if, instead of us deciding now, when there's so much unknown, what if we let our surviving spouse decide, not now, but within 9 months after we die? This can be a huge benefit because our spouse will know a lot more. Let's say you're doing wills and trusts now, and maybe you die in 5 years, 10 years, 15 years, 20 years. There could be a lot of changes between now and the time of your death. But what if we say, I leave it to my spouse, and we're going to let her decide? And first, we're going to name my spouse as the primary beneficiary. We're going to name my kids equally as the contingent after the surviving spouse beneficiary. We're going to name trust for grandkids, typically for the children of a predeceased child. Okay? Well, how can you do that? And how does that work if the goal is to let our spouse decide? What we can do is we could use a concept called disclaimers. Disclaimers say you don't have to accept any money that is left to you. So let's just say, for discussion's sake, I'll use my grandfather as an example. I leave, and I'm just going to use a number, $100,000 of my IRA to my daughter, Cindy. But I'm going to put in additional language that says, if my daughter, Cindy, disclaims that $100,000 IRA, it can go to a well-drafted trust for the benefit of her daughter. Or in a traditional situation, I leave the money to my spouse, but my spouse, I will give them the right to disclaim to the kids equally. Or to the kids, I leave money to the kids, but I give them the right to disclaim to trust for the benefit of my grandchildren. And all these decisions get to be made within 9 months of the date of your death. And for, as an estate attorney who has been involved in the preparation of well over 3,000 estate plans that we started doing back in the 90s. And by the way, I read about this solution. This isn't a totally unique my idea. I read about it in kind of some obscure literature. I thought, wow, this is unbelievable. And I started implementing this on my own in the mid-90s. I didn't get permission from anybody to do it. I just thought it was a great idea. I actually contacted the author of the article, and it worked perfectly because I was a strategy guy. And this is a great strategy because it can allow so many additional options that the traditional documents didn't have. And again, we've prepared, over 3,000 documents with these concepts in it. And most of our clients are still kicking, but quite a few have died. And the built-in flexibility of what I'll call this Lange's Cascading Beneficiary Plan has saved people a ton of money. All right. And by the way, I should mention I am not here. I did sell my law firm, so I am not trying to solicit legal business or estate planning business. I can help with the concepts. I can refer you to somebody. But I don't want to give you the impression that I am out, as I was for most of my career, looking for legal work. But anyway, I will just tell you that it worked out exceedingly well for the family of the person who did die. No one can force you to take a bequest. The money goes next in line. So I like to be very clear. I leave the money to my spouse, but if my spouse disclaims, it goes to my kids equally. If one of my children disclaim any money that was left to them, either directly or through disclaimer, I give them the option to disclaim to my to that child, and that money that the child disclaims will go into a well-drafted trust specifically for the children of that grandchild, of that child who disclaimed. I like to make it crystal clear, what happens if there's a disclaimer, where does the money go, how's it treated, blah, blah, blah. And typically you have 9 months after death to decide, so you don't have to run to the attorney's office with a big important decision after a death. And I think that this disclaimers have worked out exceedingly well. Typically, spouse first, then we used to do a B trust. We're not doing that anymore unless there's really unusual circumstances. So first to, let's call it grandma, then to kids equally, kids, then to grandkids. And it has worked out exceedingly well. I'll do 1 or 2 stories and then I will take some questions. Facts were changed to preserve confidentiality, but I'll just oversimplify. Mom and dad had $6 million. They had 3 kids. Mom's needs were not enormous. 3 million was way more than she would ever need for her lifetime. And dad died first. Mom, upon my advice, mom disclaimed $1 million to each of her kids. $1 million each. The kids used the money differently. One beefed up his retirement plan. He made Roth conversions. He funded college education, spent some, saved the rest. Another one disclaimed a significant amount of money to their kids. Another one bought a vacation home. So, and then mom died 10 years later. So the kids got the advantage of the use of that money at the first death, not the second death. So anyway, it worked. Disclaimers have worked out exceedingly well in practice. I could do story after story of tax savings and other life-changing events by including the concepts of disclaimers in your planning, which I think a lot of times save taxes. A lot of times it was a better use of money at the right time. Without having those disclaimers, those benefits would have been wasted. I have put together, I actually have a trademark on this, the Cascading Beneficiary Plan. I prefer to call it Lange's Cascading Beneficiary Plan. And I would say that it works for wills, it works for revocable trusts, IRAs, for retirement plans, for Roth IRAs, for annuities, and it builds in a lot of flexibility. So with that, before I go on further, I thought I would see if there were any questions on, let's say, the disclaimer or the Secure Act, or let's say this whole idea, which if you've been following me, you've been hearing this since I've been doing it since the mid-90s, peer-reviewed in 1998, but then it's been in all my books, all my literature, and in all my estate planning workshops. So this is not some new wild cowboy idea. This is something that I've been doing and clients have been benefiting for many years. But I will say that in today's environment, with the increased uncertainty, is even more important. Erica, why don't we take some questions?
So the first question is about one of the topics that you covered early on in the webinar, and I think it's a pretty quick answer, but Vicky asked, with respect to the gifting to heirs, does the donee have to pay tax on any gift over that $19,000 annual exclusion?
They do not. Now, if you make, so the question again, do the heirs have to pay income taxes on the gift? The answer is no. It's a little bit like transferring the orange tree. There isn't a tax at the federal level on that transfer. Now, let's say that the gift is cash, and let's say that she gave him $100,000 in cash. No taxes on the gift. Now the kid invests the $100,000. Let's say that they don't they just put it in a brokerage account, and that brokerage account earns dividends and interest. The kid will have to pay taxes on the income, the realized dividends and capital gains and interest, but not on the gift itself.
Thanks for that clarification, Jim. The next question is actually from the last session, but you had actually just mentioned, I thought this was a really great question, and you had also just mentioned that the Lange's Cascading Beneficiary Plan is something that you've been using for many years, advocating for many years, but that particularly in the current landscape of uncertainty, that makes it an even better plan. And this is a question from Thomas, and he asked, given the current economic market and political landscape, how are you and the advisors at your firm, the CPAs and financial planners, adapting your retirement and estate planning strategies? Are you approaching tax minimization or financial projections differently than in past years?
The answer is we're not ignoring the current political and economic climate. We've always been a big fan, for most people, not always, and not for second marriages in situations when it doesn't apply, which does happen. We haven't really changed most of our recommendations for estate planning. By the way, most estate plans, most wills, trust, beneficiary designations of IRAs and retirement plans, they're miserable. You can ask the CPAs, because one of the things that we do when we either do a financial master plan or assets under management is we take a hard look at your estate plan. And even though we are not drafting attorneys, we will make recommendations. And depending on what state you live in, we might know of an estate attorney that will do the estate plan that we like, but I'm rarely happy with somebody's will, trust, estate plan. I'm just amazed at how botched I think many of them are and how ill-suited they are. A lot of times lawyers are just taking a boilerplate estate plan and they're throwing it at every situation, whether it's appropriate or not, which is why I love the financial background and the tax background and the estate planning background that I can bring to the table. But I'll just say the documents we're recommending are not necessarily different. I will say that, very frankly, we are being more conservative with our Roth IRA conversion advice for a couple reasons. Up until relatively recently, we actually thought that the Tax Cut and Jobs Act of 2017 was going to sunset in 2026. So we were kind of anxious to do our Roth conversions before the tax rates went way up. Now we're thinking, well, President Trump is not going to be happy about what's going to be perceived as a big tax increase. So we think that him and the Republican Congress are going to extend the Tax Cut and Jobs Act of 2017, which is giving us additional time, at least until 2028, hopefully, before tax rates are going to go up again. So we're not as aggressive as we might have been in the past regarding Roth conversions. And the other thing is I started this workshop on the Roth by talking about some of the problems with the economy right now and some of the predictions by some pretty smart people of a potential recession. So I'm not, where you 10x your money in the S&P from 1998 to 2024, I'm not quite as optimistic for that kind of continued growth over the next, say, 20 years for reasons that I went into at the beginning. Does that mean that there's no opportunity for Roth? Absolutely not. I still believe there is. I still think that a lot of multi-million-dollar or even million-dollar IRA owners can benefit from Roths. I will just say that, and typically it's not our choice. We present the analysis and let you choose, but it comes typically with a recommendation for us. And our recommendations, I will say, are more conservative than they were even a year ago. Hope that answers the question.
And the next question is actually one that was submitted before the webinar, specifically for the estate planning webinar, and it's from Jerry. And she asks, hi, Jim, could you talk about options to avoid probate on my assets held in PA in order to avoid PA inheritance taxes for my children residing there?
Okay, I'm thinking of that. There's a movie where Vinny asked, or the district attorney's asking a supposed car expert on a particular motor vehicle, and her answer is, the problem is the question. Avoiding probate does not cut taxes, right? Avoiding probate is a method of avoiding additional estate administration. So let's just keep it real simple. Let's say you have $1 million of plain old after-tax dollars. So we're going to keep it real simple. And you leave that, you have a will that says, I leave my $1 million of, or whatever I have, to my child. And let's keep it real simple, one child. And you die, and the will says, I leave $1 million to my child. The child gets the $1 million. There's no federal transfer tax because it's well less than the exclusion, but Pennsylvania does have a PA inheritance tax of 4.5%. So that child would have to pay $45,000 on the bequest of the $1 million. Many states do not. Pennsylvania does have one. So what this woman wants to do, she says, hey, I want to avoid probate. So what she could do if she wanted is she could, instead of just having the money go through a will, she could set up a revocable trust. And then she takes the $1 million that is currently in her name, and let's say her name is Cindy Schmo. And she creates the Cindy Schmo Trust. And the Cindy Schmo Trust says Cindy can do whatever she wants with it during her lifetime, but at her death, the money goes to her child. So what would happen is the money wouldn't be controlled by her will, which says it goes to the child. It gets controlled by the trust, which also says it goes to the child. So the child's going to get the $1 million either way. The child's going to have to pay $45,000 inheritance either way. The advantage of avoiding probate is estate administration simplification. And you're not paying an attorney either for their time or a percentage. It's not a matter of public record. There's a lot of advantages of avoiding probate, but saving taxes is not one of them. And I think it's misleading when attorneys run ads and say, avoid probate, save taxes. No, you avoid taxes by strategic planning and gifting and disclaiming and doing all these other things, but avoiding probate avoids administration complications, not taxes. Hope that helps. Why don't we take one more and then we'll move on.
Thanks, Jim. That's actually a really useful, I think. We don't get questions like that a lot, but I think that was actually a pretty useful opportunity to clarify that, because I bet a lot of people are laboring under that misapprehension, not just based on ads, but definitely some misleading information that they might see out there from attorneys. We have another question from the live room. This was an interesting one. Usually we get the opposite of this kind of, but someone asked, Kay asked, do you think that the stretch will come back for Roths? Do you think they'll undo that change?
No. Um, Earlier, I said it's easier to get money from dead people than alive people. That was the idea of the Secure Act. They were going to get income taxes from our heirs. You would have thought that there would have been a huge political backlash when this came out. In fact, it was one of the few incidences where I professionally got involved in, quote, politics, and I created something called Save Our Stretch. And I was going to try to be a political influence when it was introduced. I was going to try to save the stretch IRA. And I was telling people, write to your Congress people, do the, and it passed overwhelmingly, meaning I was not a political force to be reckoned with. But who knows? You can never tell. I can't see the stretch coming back. I'm really glad they preserved the exceptions for the surviving spouse. I'm really glad they preserved the exception for a child with a disability, for the charitable remainder trust, but I don't see that coming back. Okay, I think I'm going to have to move on because I have a bunch of other stuff that I do want to cover. All right, and if I could have control of my clicker again, I don't know if, there we go. Okay, so the next concept I want to talk about is a concept called who gets what. So what happens in, I don't know, probably more than 95% of the documents that I see is that all asset classes are treated the same, both in the preparation of the wills and trusts and revocable trusts, as well as what happens even after disclaimers. So let's say you have two kids. I leave the money first to my spouse and then to my two kids equal. Well, what does the IRA beneficiary say? I leave the money to my spouse, to my kids equally. What does the Roth IRA conversion beneficiary say? I leave the money to my spouse and then to my kids equally. Well, that's a good starting point. But what if we can save a lot of money in taxes by controlling who gets what? So let's assume for discussion's sake that maybe you're married, or in this case, it doesn't matter. But let's just say that your kids are in much different circumstances financially. What I'd like you to do is think of your whole estate as a big pie, okay? And let's assume, to keep it simple, that you have kids in significantly different circumstances. And let's assume that you want to have money go to the child, to your spouse, to your kids in different circumstances, your grandkids, and your charity. Well, who's going to benefit from your estate? Well, spouse, kids, grandkids, charity, and Uncle Sam, especially if you have a big IRA. So let's say you have this big estate or big IRA. You have these different beneficiaries. What if we can give Uncle Sam a smaller slice? Uncle Sam, I'm not going to say zero. I hate those ads. Oh, pay zero taxes. A lot of that's crap, but Roth IRAs is the best way to pay zero income tax. But anyway, let's assume for discussion's sake, we want to have a smaller slice for Uncle Sam. Well, if we are successful in doing that, then everybody else can have a bigger slice. Well, that's pretty cool, right? How can we do that? Let's talk about a couple easy strategies. Let's say, for discussion's sake, that you want to leave $100,000 to charity. In virtually every document that I've read, every will revocable trust, beneficiary designation, retirement plans, it will say something like, I leave $100,000 to charity, typically after my spouse dies. It's easier to be generous after both spouses are gone. And then what does the will or the revocable trust says? After my spouse is gone, to my kids equal. Well, is that the best? What if your kids aren't financially equally? That's another strategy that we are going to cover. First of all, who gets what for charity? Charity doesn't care about tax. You leave $100,000 to charity, they don't care if it's after-tax dollars, they don't care if it's IRA, they don't care if it's a Roth IRA, they're a tax-free entity, they're not going to pay income tax. But your heirs are tax-paying entities. So instead of leaving the money to a charity in your will or in your revocable trust, which practically everybody does, what if you switch who gets what? I leave $100,000 to XYZ charity after my wife and I die from our IRA. Charity doesn't care, they get $100,000. But the $100,000 that the kids suffer as a lot, because you gave money to charity, they didn't lose $100,000 because ultimately they were going to have to pay tax on it. And let's forget about the 10 years, et cetera. Let's just assume a flat tax of 24%. They in effect only lost $760,000, which means you save the family $24,000 by just switching who gets what. I hardly see anybody doing that. That's only on a $100,000 bequest. A lot of opportunity for tax savings that hardly anybody's doing, that is really kind of a simple and, to me, obvious thing. And I'll be honest with you, the first, couple hundred, maybe even more wills and trusts that I did the same stupid thing. Now, the way I like to plan is we're going to take care of charity with IRAs. And by the way, that's one of the reasons why we don't often convert everything to a Roth. Part of that is tax. A lot of that is tax brackets. But a lot of it is we want to preserve whatever money we want to leave to charity in a traditional IRA or retirement. Okay, that's the who gets what for charity tax savings of $24,000. And most estate attorneys do botch this. All right, another example. Let's say you have two kids financially much different. One kid is in a high income tax bracket, they have a lot of money, it looks like they're going to continue to have a lot of money, and they're paying lots of taxes. The other kid, for whatever reason, doesn't have a lot of money and or is in a low tax bracket. Okay? How do most parents do this? Oh, I want to keep it equal, even though the one kid's doing better. I'm going to leave 50-50 of all the money to each of the kids. Well, what if we take a look at who gets what? The Roth isn't going to help the kid who's in a low tax bracket very much, but it'll help the kid who's in a high tax bracket quite a bit. So what if we leave more money to the child who's not doing well with after-tax dollars, and we leave the Roth money to the kid who is doing well? And what we can end up is we can end up saving, we cut Uncle Sam's slice. So we save a lot of money. And am I going to do this if I'm going to save $5,000 or $10,000? Probably not, because it is a complication and I'd prefer to simplify. But what if I could save $100,000? What if I could save $200,000? Then I'm willing to enter some complications. Hardly anybody's doing it. We are. I'll introduce this concept here, where you leave taxable IRA money to the child in the lower tax bracket and the Roth or the after-tax dollars to a kid in a higher tax bracket. Or what we're having my father-in-law do is leave an IRA to a special needs trust because they can stretch that special needs beneficiary. My daughter can stretch the inherited IRA over her lifetime. And the idea here is I'm not trying to have one kid get more money than the other, which is a different topic. I'm not saying that that's never appropriate, but I'm looking to save taxes for the whole family. And then somebody has to do some thinking, because if we're trying to equalize that, then we want to, you're not going to just say, okay, one kid will benefit a huge amount, the other kid won't benefit at all. No, you want to be fair. All right, so why don't we take a few more questions and move on from there.
Great. And by the way, thank you, everyone. Once Jim started taking questions, you really filled up the Q&A with a lot of really great ones, specifically about estate planning. But if you have any more, please keep them coming too. This question, Jim, comes from Linda, and she says, given the uncertainty about the survival of step-up in basis, how would a person decide about gifting to kids out of taxable funds versus out of your regular IRA? If the step up survives, it would be better to gift out of IRA.
Very good question. And we are facing that right now. This is something where you can't, quote, run the numbers, because we're taking a guess as to when this step up in basis is going to be eliminated. My best guess is it's not going to be eliminated before 2028, though I could obviously be wrong. So then it becomes a matter of life expectancy. Let's take the two extremes. One extreme that we're actually working with right now. Somebody is 99 years old. They have a significant amount of money in highly appreciated assets. Well, that's not a great gift. That's not a great plan to gift that money, because if we hold on to that money and then that person dies, then that money can be then the money can be liquidated and nobody pays a capital gain. Whereas let's say that let's keep it simple. Your basis is $1, the fair market value is $1 million. You gift that $1 million while you're alive. Your heir then sells it. They have to pay tax on $999,999. Example number 2, the person with a basis of $1, $1 million value, they die, then that money is passed through their will or trust or however. The child the child sells it, no capital gain. So that's the step up in basis. We typically want to preserve that. If somebody's 99 years old or we think isn't going to live a long time, then I'm interested in preserving the step up in basis. And by the way, on the investment area, I'm not anxious to sell that highly appreciated stock, even if I don't like the investments. So what I might do for that person is I might say, okay, let's hang on to your highly appreciated stock, not incur a capital gain, and then to get you better balanced, let's take some of your other money, maybe money that's in an IRA that isn't going to be subject to income tax if you sell it, and then you get some kind of much better diversified portfolio. So that's an example, by the way, of what's called asset location. So you might end up with a similar asset allocation, but a radically different asset location that saves a lot of money in taxes, because we're not having the 99-year-old sell off all their stock and pay a huge capital gain. Let's take the other extreme. You're in your 50s. It's pretty obvious that you're going to survive the step up in basis. Then I would not make the step up in basis a big factor. Where you are, most of the people on this call are going to be in between. I would say it is typically overrated to plan for the step up in basis, particularly if the investments are inappropriate. And particularly, this happens a lot, if there's a high concentration of one stock. then it becomes even more dangerous. And, like some of the people who've lost their shirt by having a high concentration in stock, uh, they really got hurt. So I'll just say that that might be a situation where you just say, hey, I can't worry about the step up in basis. I have to sell some stock, maybe use that for gifts. Why don't we take one more and then I'm going to move on. I'm just looking at the time and we don't have as much as I think.
Okay, absolutely. So I was going to bundle two sets of two questions each. So I'll just go with the first set. These are questions about beneficiary who disclaiming and beneficiaries. The first question is really simple. It's from Charlie, and he says, "Does each beneficiary individually have the right to disclaim their inheritance?" And then the second question, which was a little bit more complicated, it was from an anonymous attendee, and maybe they can clarify this because I think you'll need to make some assumptions here, Jim, but they said, can state claim disclaimed funds when beneficiary is on SSI or SSDI? So I think that the real question maybe you would want to answer there or try to address is if someone is on SSI or SSDI, can they be the recipient of, not necessarily can they disclaim, but can they be the recipient of funds outright in a bequest?
Well, first, I'll take the first part first, and then no, the second part first, then the first part. One of the things that I do, which is perhaps a mistake, is I usually assume that the people I'm working with will eventually do what is the right thing. If you have money and a beneficiary or even a contingent beneficiary is a child with special needs, and if we're going to get technical, a child that qualifies as an EDB, eligible designated beneficiary, you don't leave money to that child. You leave money to a special needs trust. And then we can get into even additional complications after that. But one of the points of this trust is to protect that money from the government. So you always want to get the planning right, and can money that otherwise would have gone into a well-drafted trust for the benefit of the child that would protect the child from the government, which is one of the potential creditors? The answer is absolutely yes, but that's assuming good estate planning, which we often don't have. And it's amazing how bad the estate planning is for a lot of people who have a child or a grandchild with a disability. And by the way, there's unbelievable opportunities. I mentioned the one for my father-in-law to provide for our daughter, and through disclaimers. But it's not, I leave the money to my daughter, and if she disclaims, I leave it to my granddaughter. It's, I leave the money to my daughter, and if she disclaims, then the money goes into a special needs trust for the benefit of my granddaughter. All right, now I'll take the second question, the first part of the question, which is, can anybody disclaim? Yes. The problem with disclaiming is, where does the money go? You can't say, I disclaim it goes to Joe. I disclaim it goes to my kids. I disclaim it goes to my boyfriend. I disclaim it goes to charity. It is up to the person drafting the document that says where it goes if somebody disclaims. If my son disclaims, it goes into a trust for the benefit of the children of that son that disclaims. If my son disclaims, it goes to the XYZ charity. If my spouse disclaims, it goes to my kids equally. I like to be crystal clear on what happens to the money if somebody disclaims, because the question of disclaiming, it might be how much, it might be IRA, it might be Roth IRA, it might be after tax. You can even disclaim jointly held property, which is another complication. But I like to be super explicit in the documents, meaning wills, trusts, beneficiary designations, of where the money goes during a disclaimer. I hardly ever see this done right. And I'm afraid I'm going to have to move on. All right. So we had a little discussion in one of the questions, so I'm not going to beat it up again, on probate, and the benefit of probate is to simplify estate administration, not to save taxes. And that's really important. So you're going to see me skip a few slides. But if you do set up this trust, the trust can be revocable, which just means you can change it whenever you want, which is what I'm going to do maybe 98 out of 100 times. It can be irrevocable if there's a good reason for you not to change it. We had a situation, well, I don't have time for stories. I love stories, by the way. But, well, we had a situation where people were exploiting an older gentleman. And we, with his agreement, we put his money in an irrevocable trust. So literally the people exploiting him could not get to it because we named his child as the trustee, which is a risky thing to do, but in that situation, we needed to do it to protect this older guy who was being exploited by other people. The other thing is sometimes you use a trust to control from the grave. Typically, a revocable trust is funded while you're alive. You and your spouse are the trustees, protects. Then there's trust for minors, which protects the child from themselves, protects against a child's creditor, protects the money from the other parent. That's become more and more popular where people don't trust their son-in-law or daughter-in-law. So they want to make sure that any money going to their child is protected in a trust that is protects against creditors. And the most likely creditor is your future ex-son or daughter-in-law. The other thing is you can say how you want the money to be spent, typically health, maintenance, support, education, not sex, drugs, and rock and roll. Although I have to admit that I was on Facebook, there were two pictures. One was Mick Jagger, who's this like athletic, healthy guy who looks great. And I think he's 80 years old now. And Mitch McConnell, who's the same age, and Mitch doesn't look as good. So I don't know, maybe sex, drugs, and rock and roll isn't such a bad thing. But anyway, typically that's not why we leave money to a young beneficiary. Sometimes we say, okay, health, maintenance, support, education, a third of 25, a third of 30, and we terminate the trust at age 35. Some people go 30, 35, 40. I've actually had somebody that said the kid doesn't get a nickel until they're 65, which I thought was a little harsh, but I failed to change that person's. Typically, you do trust for minor beneficiaries, even if they are contingent beneficiaries. And so again, I leave the money to parent, but if parent disclaims, it goes into a trust for a minor beneficiary because subject to exception, we don't want the minor beneficiary to go out and blow it on sex, drugs, and rock and roll when they are 21 years old. So now I'm going to get a little touchy-feely with you. I'm going to go to Carl Jung, the great psychologist, and he teaches us, says there's basically two types of people, although I guess we're all some combination of the two, but usually an emphasis on one or the other. And he calls them judgers or free spirits. So judgers have a certain way of thinking. Their idea is they want the rest of the world to conform to their worldview. Judges like to plan. All right? I will admit, I'm a little bit of a judger. I have certain ideas. When you are working, you should put the maximum, typically in Roth IRAs and Roth 401ks, should be a substantial part of your salary so that you can enjoy a work-free, if you want, and relatively plentiful retirement. And the way to do that is to start early while you are working, all right? I think that you should, when you're young, you should have term life insurance, not expensive whole life. That you should as you age, you should be even more cognizant of Roth IRA conversions, that you should have wills and you should have the disclaim. So I obviously have a lot of stuff that I want to happen. So I'm not going to change my view to accommodate the rest of the world. I am, one of the things I'm trying to do today is I'm trying to get some of the world to adopt some of the ways I'm thinking. All right, that's a judger. The free spirits, oh, well, whatever happens, happens. I'll adapt. If the wind's going this way, I'll go that way, or I'll go this way, and I'm going to conform myself to the rest of the world. It's all good. So, if you have an adult beneficiary and you have some worries about that beneficiary, it's okay to be a judger and say, hey, I'm not going to give the beneficiary the option of blowing their money. I'm going to have the money go into a trust for the benefit, even if it's an adult beneficiary. I will tell you when I've done some variation of this workshop for, well, I hate to say it, but for more than 30 years, because I came up with this idea roughly 30 years ago, maybe 25 years doing workshops. And I would raise my hand, ask for hand raises. Most of the people said, yeah, I'm a judger. The free spirits, they're at the mall. The judges are the people who attend workshops like this. And if that's true, you want to protect your adult child from creditors. You want to protect your children from future ex-spouses. Of course, it adds some complications. If the underlying assets are IRAs, or extreme care is needed, there's an extra tax return. So I'm not going to, you have different treatment for siblings. So I'm not going to say that there's no problem for trust. I'll just say a lot of times it is important. And I'll do one quick trust story and then we'll move on. So one day I was reading the Wall Street Journal, which, by the way, I'm going to kind of give them some kudos. They're saying a lot of scary things about the economy that I would have expected to read in the New York Times, not in the Wall Street Journal. I would have expected the Wall Street Journal to kind of toe the line a little bit more, but they are not, to their credit. They're saying it the way they think it is, which is what I talked about earlier, which again creates even additional uncertainty. But anyway, this area, I don't think the Wall Street Journal did too well. There was an article in there and it said that if the underlying asset is an IRA, it's very complicated to draft a trust if the beneficiary is a trust. Let's say that you want to leave money to, let's say, a troubled child or a kid with a disability or a young grandchild, or where a trust is clearly indicated. This article said, because it's complicated to get the trust right, you shouldn't name that beneficiary. You shouldn't name that trust as the beneficiary. I'm thinking that's terrible advice. You want to name the beneficiary who's appropriate. And if they name a trust, just draft the trust. And if there's a tricky trust because the underlying asset is an IRA, then just go to an estate attorney that knows what they're doing and that they fill the beneficiary form out right. Anyway, I was kind of mad. I said, this is terrible advice. I write a letter, Dear Wall Street Journal, I think you gave very terrible advice. If the underlying asset is an IRA, the solution isn't to not name that beneficiary but is to name a trust for the beneficiary and get the trust right. Anyway, that day, I used to have a radio show. I had a lot of the top people. I loved it. I had Jack Bogle on a couple of times. Most of the then famous IRA experts, a lot of the investment experts. And I was able to ask, I actually read their books, which was great. That by themselves was a great education for me. And then I asked all the questions that I wanted to. But anyway, one of the guys that I had on as a guest was a guy named Bruce Steiner. He's in his 70s, probably almost 80. He's still out there giving workshops and educating folks like me. I'm not as old, but I love what he's doing. Anyway, I just started the radio show. Hi, Bruce, how are you? I'm furious. What's the matter? He said, the Wall Street Journal ran an article today, and it said when the underlying asset is an IRA, that you should not name a trust as the beneficiary of that IRA because it's complicated. And it is much better to name a trust that is well drafted and just go to an estate attorney that knows what they're doing. And that way you get the tax benefits and you get the asset protection. And that is a much better answer than what the article said. Basically, and I was so mad about it, I wrote a letter to the Wall Street Journal. Anyway, that was basically the exact same letter. And I just thought it was interesting that we did it independently. And by the way, the Wall Street Journal didn't publish either of our work. Then there's the I don't want my no good son-in-law to inherit 1 red cent of my money trust. Ever more popular. I think it makes a lot of sense for a lot of people. I prefer that there be a prenuptial, but having a postnuptial agreement, which is theoretically possible, is a great way to start a family fight. So if your kids are already in a tough situation, bringing up the question of the issue of a postnuptial is usually not a wise choice if the goal is to potentially preserve the marriage for your child, but I don't want my no good son-in-law to inherit 1 red cent of my money trust is actually a good idea. This is in situations of marital strife, influence, and when you don't trust your son or daughter. Okay, and I do like the idea of bringing up the idea of a prenuptial. You do this before the intended exists. So you don't bring this up, after the guy comes in with the nose rings and the tattoos and everything else, because your kid is going to assume you don't trust the guy. Well, it's not that guy. I don't trust any guy. I want to keep the money in the family, and a prenuptial agreement is a good way of doing it. Okay. Let's see. We actually don't have time for more. I can't stand not doing questions. Why don't we do one more question, and then I'll do a few closing remarks, and we'll take it from there. So Erica, do you want to do one more question?
Absolutely. Sorry, I was trying to find, we have so many good questions. And by the way, everyone, I did mention this in the first workshop, but I don't think I mentioned it here. We will be taking a lot of these questions, and Jim will be answering them over the course of the coming weeks on our YouTube channel. So if you didn't get your question answered today, or if you don't get it answered in the next session, because I will carry some of these over, do look for that. Okay, Jim, it's hard to decide because there are so many really good, super on topic for what you've been talking about questions. But this is an interesting one. So Larry said that he has an inherited IRA under old rules. So he got it before 2020. What happens to it when it goes to my kids?
What Larry would like. All right, so here's the situation. Sometime before 2020, presumably one of Larry's parents left him money, and Larry inherited that, and he did the right thing, which is he is stretching that inherited IRA over his life expectancy. All right, and what he would love to do, and let's say he dies when he's 80 years old, or according to the tables, he has, I don't know, say 8 more years of life expectancy. But then he dies with 8 years of life expectancy, and he leaves it to his kids who have a 45-year life expectancy. And what he would like to happen is his kids could stretch that over 45 years. But sorry, Larry, your kids have to stretch it over your life expectancy, even though you're dead. So again, Larry has, he's taking money over his life expectancy, which is taking advantage of pay taxes later, even after you die. So Larry's paying taxes later, even after his parents are gone. I still want to get the remaining 8 years after he dies. But what Larry might want to do, which is have that money go to over the kid's life, and you can't do that. So you get the remaining life expectancy, even though you are dead. All right, one more. I can't resist. I love the questions.
Okay, another question that I was planning to bundle earlier had to do with disclaiming. So Cynthia said custodians of IRAs merely ask for the name of the beneficiary. So how do you ask for a disclaimer with a custodian like Fidelity or Vanguard?
The answer is you should actually draft specialized beneficiary designations that have all the disclaimer documents. Most estate attorneys don't do that. I think they should. Most estate attorneys botch the, I'll tell you what's even worse, is sometimes they don't even fill out the beneficiary form. You know, I would not let a client touch a beneficiary form of an IRA, Roth IRA, etc., because the words that you put down matter. And it should be done by a competent estate attorney that knows what they're doing, or else you could get a terrible result in either having to go to the wrong person or having the wrong tax treatment. So I'm not going to, even if I had the words at the tip of my tongue, which I don't, I'm not going to tell you how to do it because I think you should have a competent estate attorney put in disclaimer language.
Allow me to ask you some important questions. Do you want to protect yourself and your family from massive income tax acceleration? Are you at least slightly concerned that future income and other tax increases will unnecessarily decimate your hard-earned savings and threaten the financial legacy you plan to pass on to your children and grandchildren? Are you willing to take action and defend yourself from government confiscation of your hard-earned money? Are you ready to take proactive steps that could help you and your heirs get the most out of what you've got? If you answered yes, this short video could be the most important thing you have ever watched. Imagine you could wave a magic wand and have a rock-solid financial master plan that has all your financial affairs in order. Think about how you would feel if you never had to worry about money because you had solid data that allowed you to make informed financial decisions, not guesses. How much better would you sleep at night knowing your financial master plan is in place? I'm going to share with you how you can make that happen. But first, let's talk about why it's so crucial to develop and implement your holistic, long-term retirement and estate plan. First, thanks to the sunsetting of the rates set by the Tax Cuts and Jobs Act, it's likely that your current income taxes will go up in 2026. But even if legislation is passed to enshrine the current rates before they expire, raising income tax rates isn't the only way to raise taxes. Jim Lange predicted the death of the stretch IRA and advocated defenses against it more than 5 years before the Secure Act became law. Jim had the foresight that almost no other retirement and estate planning experts did. He understood that the end of the preferential tax treatment of inherited IRAs and retirement plans wasn't a matter of if, it was a matter of when. Now Jim predicts higher capital gains tax rates, changes to federal tax exemptions, elimination of step-up in basis rules, and estate tax increases. Congress pulled a bait and switch on you, and it was just plain wrong. You were promised that contributions to your IRAs and retirement plans would pass to your heirs with significant tax advantages. Remember the stretch IRA? Because you were fiscally responsible, you acted on that promise. You sacrificed so you could put as much money as you could into your retirement plans. Then, late in the game, Congress pulled the rug out from under you by passing the Secure Act. The consequence of Congress's actions with the Secure Act? A massive income tax acceleration on money you thought was protected. But there is a way for you to fight back and protect your wealth from the Congress's greedy hands. We can offer you the means and the tools to pull back some of that money. There is no single strategy that will solve all these problems and ensure your future financial security. Nor is there a one-size-fits-all combination of strategies that is right for everyone. But Jim and his team will help you find the right combination for you and your family. Here are just a few of the strategies in Jim's arsenal. A series of timely Roth IRA conversions to be executed over a number of years. Social Security optimization. Lifetime safe spending analysis. Spend the right money first analysis. Appropriate asset location analysis. Estate plan evaluation. Lifetime and testamentary gifting strategy, including leveraging lifetime gifts to children and grandchildren, and our tax-savvy Who Gets What estate planning analysis. And all of these will be adapted to your unique situation and calibrated to provide the best results for you and your family. The choice to develop your financial master plan is not a choice to maintain the status quo. It's a proactive choice to improve upon the status quo and secure the future you dream of for yourself and your family. When you meet with Jim, he may propose implementing the superbly flexible Lange's Cascading Beneficiary plan. Its flexibility protects your spouse, allows for the possibility of directing money to your children after the first death, and allows for the possibility of directing money to your grandchildren with parents as trustees. These options are not available with traditional planning. Lange's Cascading Beneficiary plan is really an estate planning system that should be considered for virtually all of your assets. It works for wills and revocable trusts, IRAs and retirement plans, Roth IRAs, and Lange's Cascading Beneficiary plan is only one tool in Jim's arsenal. The first step toward peace of mind and a good night's sleep is to request a Retire Secure consultation with Jim Lange. During your 1-hour private Zoom consultation with Jim and one of his number-crunching CPAs, you'll discover how to cut your taxes and preserve your wealth. Jim will answer all your questions and concerns and likely suggest 2 or more tax-reducing strategies you had not thought about. Jim takes a multidisciplinary approach to securing your retirement. He accounts for taxes, legal, and investments. Jim has given thousands of consultations over the years and has never had anyone say or even imply that it wasn't worth their time. Why? Because Jim delivers real-world value and not a sales pitch. At the end of your Retire Secure consultation, you will have the outline for a concrete plan of action to maximize your retirement prosperity and generational wealth. Then you will have 3 options. You will thank Jim for his time and valuable recommendations and most likely end up doing nothing. You'll want Jim and his team to run full retirement and estate planning projections, producing your personalized financial master plan for a one-time investment of between $12,500 and $22,500, depending on the complexity of your situation. Or you'll want your personal financial master plan, and you'll want Jim's team to help you implement the plan, and have one of Jim's strategic partners manage at least a portion of your assets. If you select option 3, your personal financial master plan is included for free, and your personal financial master plan will be updated every year at no additional cost, provided you place a minimum of $2 million under management. A no-obligation Retire Secure consultation will likely provide you with at least one idea worth 10 or even hundreds of thousands of dollars. You can get it now for free, without obligation. The purpose of the Retire Secure consultation isn't to sell you. It is to determine if you are the right fit to work with Jim and his team. Please note that Jim will not take you on as a client unless he thinks he can save you and your family many times his fee. Jim only has a limited number of slots available for the free Retire Secure consultation before there is a waiting list. Since Jim personally conducts each consultation, and there are hundreds of attendees on this virtual event, Jim will almost certainly not have enough available appointments to meet demand. In addition, Jim's team will likely not have sufficient time to meet demand for financial master plan development. Developing each financial master plan is a time and labor-intensive process, and with ongoing obligations to existing clients, Jim and his CPAs only have so much capacity to take on new clients. So, to secure your free Retire Secure consultation with Jim Lange, click the offer link and complete the appointment request form now. Listen, with the uncertainty in the country, It's natural to be concerned about your financial future. But with proper planning, you can protect yourself and your family from massive taxation, get the most out of what you've got, and maximize retirement prosperity and generational wealth. And the first step is simple and free. Click on the offer link and request your Retire Secure consultation with Jim Lange. Don't wait and be disappointed. A happier, less stressful, and more abundant life awaits. Take action to secure your family's financial future now. Request your free Retire Secure consultation by clicking on the offer link.